Hi, this is Arikeshna Mukkala. Today we are going on topic called legal aspects of international business with, in United Studies on Blondek, Tull, Castle and Lowry. Going to background of this case, uh, we are seeing Blond and Tull was the president and vice president of Eagle Manufacturing Company. They deal with a manufacturing and marketing of buses in Texas, USA. Castle and Lowry was president and vice president of Foreign Transit Company. In 1989, Eagle Bus Manufacturing worked out a deal for the sale of buses to Saskatchewan-based company. To finalize the deal, the Saskatchewan company asked for bid from Eagle Bus Manufacturing Company. The case filed in 1990. American Department of Justice filed a case under the provisions of Foreign Corrupt Practices Act 1977 against them. They were accused under section 78DD-1 and 78DD-2. Case history is case of bribery, first settlement of a bid. Castle and Lowry, Blondek and Tull are defendants. Blondek and Tull are US nationals accused for giving bribe, whereas Castle and Lowry are Canadians accused for taking bribe, charged under Foreign Corrupt Practices Act of 1977. As we go through introduction of a Foreign Act Practices Act in 1977, in early sensitivities, the malpractices regarding bribe was increased unexpectedly in United States. There are more than 400 companies are accused for taking bribe. The bribery amount was more than $300 million, created a negative impact of market policy in the United States, created an unethical expressions over the business scenario. It also lost its trustworthiness. The foreign policy of American was badly affected. Running a friendly relationship between the foreign governments. The provisions of Foreign Corrupt Practice Act in 1977 is payment of bribe is illegal. No provisions to accuse foreign officials under the act. Prime motive is to curb domestic fraud. Though behind passing the FCPA Act was to prevent the bad impressions of bribe on foreign relations. As we go to case issue, Blondek and Tull were employees of Eagle Bus Company. They offered $50,000 were paid to the foreign officials to settle the bid called Saskatchewan Provincial Government. The Castle and Lowry were accused for accepting the bid. Issue is whether they can be accused or not under FCPA, as they are Canadian candidates. The similar act called the Maine Act in 1990. Court faced a similar issue in case of Gabriel in United States. The defendant was accused under Mann Act 1910. The transportation of women to any other country is prohibited under this act. However, it did not criminalize women who willingly participate in transportation. The defendants that is submitted to this case, no provisions under the act of prosecute a case against any foreign official. Hence, they prayed for dismissal of suit. The District Court of Texas accepted their submission. The controversy behind the case is Castle and Lowry got exempted. Questions regarding their release was raised. The probability of charging them under general conspiracy statute. Judgment on this case filed. Legalization body of American has given advantage of a certain classes of parties under this act. It was observed that the Canadian government also imposes imprisonment over the officials. Canadian police started investigation against both of them. It was observed that the construction of the act is quite sensible. Therefore, the court has decreed the case in favor of Castle and Lowry, gave judgment by releasing them from the prosecution. The conclusion of this case: the construction of Foreign Practice Act is quite liberal. It aimed at exempting the foreign officials. It helps reconstructing the foreign policy in United States. The avoidance of domestic fraud and bribery. Thank you.